Have you ever been told you should set up a living trust? Well, what if I told you how easy it is to set up and exactly how to use it? Your living trust is probably the most important legal document you will ever have, and we're going to talk about how it can hold real estate and other assets, the advantages and disadvantages, and how a living trust compares to a will. In fact, a lot of attorneys will create a will, then when you die with a will, your estate goes through probate. Now, typically the attorney will collect probate fees and other legal fees to take your estate through the process before a judge and fight any challenges to the will. You will not be around to argue the fees, and the attorney can take his fee right out of your estate before anybody else gets paid. There may or may not be parameters in your estate as to how much he rakes you over the coals financially. I am the business guy, and today we're going to talk about why the living trust is the most important legal document you will ever own. So I urge you to write this down, take notes. I've been in the asset protection and estate planning field since 1991. Our company started in 1906. We have attorneys on staff who you can speak to and are one of the nation's leading asset protection firms. And if you're watching this on YouTube, please click the like button below and enter your comments. And you can also click the subscribe button so that when more videos come out like this, you'll get notified. So a lot of times attorneys don't tell you about a living trust because wills can be so profitable for the legal profession. Now keep in mind, a will only activates when you die. It does very little for you when you're alive. So this means two things. First, when people die, the heirs they designate in their wills will receive their asset. Second, the estate goes through the probate courts before their heirs get anything. In fact, some people think that if you don't have a will, your estate goes through probate. That's not the case. Your estate goes through probate if you do not have a will or if you do have a will. Now, one of the only ways your estate does not have to go through probate is to either not have any assets or to have all of your assets in a living trust. Now, if you've ever had to take an estate through the probate process, you already know it's not fun. One, you need to hire an attorney. And as you know, attorneys aren't cheap. And the more money there is, the more they tend to drag it on, racking up the fees. And that is why they will often set up a will for a few $100 because when you die, hot dog, it's payday. I mean, probate can drag on for 9 months. And if it's contested, I mean, some family members think they should get more. And we get calls about it every day, but there's nothing we can do about it because it's too late. That is, if somebody has already died without a living trust, it can take 3 to 5 years when somebody disputes the will. And it happens all the time. Say the executor of the will thinks they deserve a big fee for handling the whole thing and starts to plunder the estate, transferring the money and property to himself as compensation. And many wills don't have anything stopping them from doing so. In fact, my grandfather died with millions of dollars. I was very close to him. In fact, I lived with him and my grandmother for several years, and he always told me that was for me and my mother when they passed. Then when my grandmother died, he got remarried. When his mind started to go, his wife changed the will, he died, and she plundered the entire estate, and my mother and I got nothing. Zero. Not a penny, not even a coffee cup. We could have contested the will in probate, but she would have been using his millions to defend it, and we would have likely used hundreds of thousands of our own dollars for a chance to win or lose. So you want to do everything you can to avoid probate, the expense and the fact that everything's in the public records. Whoever wants to pry into your affairs can just look into the probate file. Now here's another thing. Say you own property in various states. You die. If you only have a will, your family will get stuck with probate fees in different states. Say you own a property in Florida, New York, California. They'll have to hire a lawyer in each state and go through the nightmare scenario 3 times. So what's the solution? A living trust. A living trust avoids probate altogether. Now, 2 extremely important things. 1, you want to set it up immediately. A few months ago, I was riding a bike, minding my own business, and got smashed by an SUV. Broke my neck, and I almost died. Hey, you never know when your last day is. So the most important advice is do it now. You can always change it later, but get it set up now. And number 2 is you need to fund it. That is, put your assets into it. So you take your trust down to the bank, open your bank and investment accounts in the name of the trust. You'll likely want to put your house into the trust, and it's a really easy process. And if you're married, you can have one trust for both spouses. When your spouse dies, the surviving spouse is the beneficiary. When you both die, the assets pass down to your beneficiaries. Now, this is where you get to control your assets after you die. Now, they don't have to get all of your assets at once. And here's an example. Until age 25, they receive food, housing, and education. At age 25, they receive 1/3 of the trust assets. At age 30, the other 1/3, and at age 35, the remainder. So that way they don't blow everything by impressing their friends with a Lamborghini in every color. Or you may want the trust to pay your heirs a monthly income so they never have a chance to blow through it all. You can require them to have a college degree before receiving some or all of the inheritance. Perhaps they start a business or it shows a certain amount of profit. So you can set milestones so you're not just paying somebody to sit around on their backsides and wait for their next trust fund check. So you really need to consider who you want to receive your estate and how you want them to receive it. And one other thing I found in this business, inherited money spends easily. Always remember that. And though I think my kids are very responsible, I don't want my kids and grandkids to blow through their inheritances until they have nothing left. So I'm going to leave a legacy for them so they receive a monthly income as long as they have college degrees, which my kids do, and are gainfully employed or running their own businesses. So they are not receiving all the assets outright because we are going to have them held in trust for their benefit, their children's benefit, and their children's children's benefit. My plan is to build a legacy for future generations. Now, if they got all the assets in one lump sum, someone along the line would get divorced, get into a lawsuit, and poof, they'd all be gone. So I'm not going to do that. They're going to respect that money and not go out and buy a Bugatti because they think it's worth more than having an investment that will spit out income for years to come. And that's the reason we have created the trust. Now, you can have yours set up however you want. Maybe you were married before and have children from another marriage. When your current spouse passes, you want her to get her fair share, and then you set aside some so that all of your children can get a piece of your estate. So the key thing is, hey, it's your trust. You can control your estate from the grave because you are the one who decided how to set all this up. And you don't have to deplete your estate with all kinds of crazy probate fees or attorney's fees to distribute assets to your beneficiaries. Now, let's discuss putting your assets into a living trust. Okay, now let's imagine you are moving from Seattle to Miami. The semi-truck pulls up, but they only put half of your furniture and things into the truck, and the rest they leave out in front of your house on the sidewalk next to the truck. Then the truck drives off to the new house with half of your things still sitting there. And that's what it's like setting up a living trust, but not putting all of your assets into the trust. Everything inside the truck bypasses probate. Everything outside the truck goes through probate. So then you have to pay some other guy $3,000 to get the rest of your stuff. And that's what it's like having to pay probate fees for leaving some of the stuff outside of your trust. Now, if you want your living trust to control your assets upon your death, you need to put your assets into the trust. And your assets go into the trust in 3 ways. Number 1, changing the title of the property. Number 2, listing the property on a schedule attached to the trust. Or 3, using a pour-over will. Now let's talk about these 3 ways. If a property has a title, a house, a car, a bank account, you can change the title of the item to the living trust. You file a new deed transferring your house into the trust and record it with the county recorder's office. So if you are the trustee of your own living trust, like most people are, and your name is Pat Smith, and you own a home, here's how it's done. You fill out a new deed, okay, with Pat Smith as the grantor, the one transferring the house. Next, the grantee, or the recipient, is, for example, Pat Smith, comma, trustee of the Pat Smith Revocable Living Trust, dated July 20th, 20XX, or whatever the year is. Now, you need your signature notarized on the deed, and you record it in the county recorder's office in the county where the property is located. Now, we have attorneys on staff who can help you do that. Next, you go down to the bank with your trust and move your money over into a new bank account in the trust name. And you don't need a tax ID number, just your social security number. It's really easy. Then you can re-register your car with a DMV in your trust name. Now, the second way to put money into your living trust is if the property doesn't have a title, such as an expensive art collection, a gun collection, you simply describe each item on a document that says Schedule A at the top of it, for example. You refer to Schedule A within the trust, and you can list the grandfather clock, the expensive painting, etc. And that's a schedule that lists personal property that doesn't have a title, like a house has a title. Even simpler, you can transfer some or all of your personal household items into the trust with a one-page declaration that's been notarized and witnessed. Now finally, there is the pour-over will. And it is a will where the writer declares that all of the property in his or her estate at the time of death will be distributed to the trust, and that is handled as the trust dictates. So the pour-over will is kind of a catch-all for assets that were not put into the trust. Now the assets still go through probate before the trust handles them. So yes, you will want to have a pour-over will, but do numbers 1 and 2 above with as many assets as possible. You'll also want a living trust which tells people how you want to handle things if you become impaired. Let's say you get Alzheimer's disease, you're impaired and you go into a coma. So do you want to be on life support or do you want to pull the plug? So you'll also want a medical power of attorney to pass your wishes on to the doctors and make decisions if you cannot make them. You'll want a financial power of attorney to handle your investments and accounts. Then there are the little things. Say you want your gun collection to go to a certain person, or you want your vintage automobile to go to somebody else. The schedule of gifts can handle that. People squabble over the dumbest things, so you want to minimize the tension among family members by specifying who gets what, or if they just sell everything and split the proceeds. And the great thing is, hey, it's revocable, so you can change it any time. Say they ignore you, they disrespect you. It's your money, it's your trust. You can yank them as beneficiaries, or if they kiss and make up, you can put them back in. So in summary, with a living trust, your heirs avoid the time and money killer of probate. So more money goes to people that you care about. You control what happens to your assets long after you die, so your kids, grandkids, and great-grandkids can have a head start in life. And you can make sure they act like responsible adults, get college degrees, for example. And maybe the trust can help pay for that, say depending on their grades, before they get a penny more. Remember, number 1, you'll want to set it up right away. And number 2, you want to fund it, as we talked about, and we talked about how to do that. We talked about the pour-over will, how your living trust can direct your medical and financial needs if you need help, and how these documents can direct how your kids get your assets. Now, as a business person and legal professional, I strongly urge you to get your living trust set up ASAP. It's one of the most important legal documents you'll ever have, and get it done right. You don't want to go cheap. You want to get this thing done right. And if you want to set up a living trust, give Asset Protection Planners a call today at 1-661-310-2931. We have attorneys on staff, employees nationwide on both coasts and in the middle. So visit assetprotectionplanners.com and fill out a free consultation form. And remember to click the like button below. This is The Business Guy.